Today, we will be presenting Engel v. Vitale and Wisconsin v. Yoder, both cases which relate to freedoms of religion in the First Amendment. This is presented by Ryan Nebu, Tu Nguyen, Min Nguyen, Adrian Cooper, and Hayden Schroff. The original intent of the First Amendment with regards to the Establishment Clause and Free Exercise Clause was to prevent the government from establishing an official state religion or to adopt an existing religion and make it the official state religion. It was also intended to create a separation between church and state, though this was not directly stated but instead implied. Another original intent of the First Amendment with regards to religion is that the government may not pass laws banning certain religious practices. These clauses apply to Congress and prevent them from passing laws which do the aforementioned policies, and were not applied to the states when the Bill of Rights was first ratified.
Important dates of the First Amendment included the ratification of the 14th Amendment, which allowed for selective incorporation, Cantwell v. Connecticut, which held that the 14th Amendment's Due Process Clause makes a Free Exercise Clause applicable to states, Engel v. Vitale, which ruled that state-composed prayer violates the Establishment Clause, Lemon v. Kurtzman, which introduced a three-part Lemon test for the Establishment Clause, and Wisconsin v. Yoder, which ruled that children couldn't be required to attend school once they reached the age of 16 because it would violate the free exercise of religion. Some other dates are also included.
In the modern world, courts have incorporated the Establishment Clause and the Free Exercise Clause by the 14th Amendment and the subsequent court cases. Everson v. Board of Education incorporated the Establishment Clause, and Cantwell v. Connecticut incorporated the Free Exercise Clause. Lemon test, created by Lemon v. Kurtzman, states that the Establishment Clause is violated if statute lacks secular purpose, or if the principal effect advances or hinders a particular religion, or it fosters an excessive government entanglement with religion. With regards to the Free Exercise Clause, states must meet strict scrutiny standards to prevent religious conduct and have compelling reason to do so. This Sherbert test also requires offended individuals to prove their sincere religious beliefs and how the government action is creating an undue burden. Some limits to the religious freedoms included in the First Amendment are that public schools cannot have forced school-led prayers or voluntary school-led prayer. There can be no graduation prayer, polygamy is banned, and students may not be forced to attend school if it violates their religious beliefs.
In Engel v. Vitale, there was a New York law that states that public school students are required to start the day with the Pledge of Allegiance and a voluntary prayer, which read, "Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country." A group of parents protested the prayer, saying that it violated the Establishment Clause of the First Amendment, and one parent in particular, Stephen Engel, decided to go a step further and sue the school board president, William Vitale.
The constitutional citations for Engel v. Vitale is the First Amendment's Establishment Clause was the constitutional citation concerned. Additionally, the constitutional question before the court was, does the non-denominational prayer read before school violate the Constitution's First Amendment Establishment Clause?
The Supreme Court's ruling was released on June 25, 1962, with a 6-1 majority judges deciding that the prayer did violate the First Amendment, even if it was voluntary. Although the prayer was voluntary, the First Amendment was supposed to protect any kind of government interference with religion. Therefore, the voluntary prayer that connotes one religion would violate the freedom of religion that American citizens are supposed to have.
In Wisconsin v. Yoder, 3 Amish parents refused to send their kids to school past the 8th grade, pulling them out at age 14 or 15. The Wisconsin state law makes it mandatory for children to go to school until the age 16, and therefore fined the Amish parents $5 each for violating the law. The parents opposed this violation, and one parent in particular, Jonas Yoder, took the case all the way to the Supreme Court, saying how it violated the Free Exercise Clause of the First Amendment. The constitutional citations for Wisconsin v. Yoder is the First Amendment's Free Exercise Clause was the constitutional citation concerned. The constitutional question before the court was, did the Wisconsin law forcing students to attend school until at least 16 violate the parents' right to withhold their child from school due to religious beliefs?
On May 15, 1972, the judge's ruling came out as yes, Wisconsin's compulsory education law violated the First Amendment. The ruling was supported by how, due to the Amish way of life, children would be exposed to things in high school that would contradict their religious beliefs and would be forced to assimilate into conformity. Since the students aren't going completely uneducated, being in school until the 8th grade, the state's concern of universally educating their population was overridden. The Amish parents gave ample evidence that forcing the child to go to high school would, in fact, destroy the teachings of their religion and take them away from that religion in their most important formative years. Justice Stewart agreed to the extent with the court's ruling. He believed there was a fine line, and if the students weren't being educated at all, then the case would have ended up much more different. On the other hand, Justice Douglas believed that this case focused too much on the rights of the parents, whereas it should have been more concerned with the rights of the children. Only one child testified that they felt as though their religious beliefs were being violated, while the other two didn't testify.
Thank you guys for listening.